Everyone, and thank you all for joining us for today's presentation. My name is Marissa, an attorney with Legal Aid of North Carolina's Helpline. Today, we have Jim Morgan presenting for us. If you are unfamiliar with the format of this event, first, Jim is going to review a PowerPoint presentation. At the end of the presentation, we will have a question and answer session. If at any point during the presentation you have questions, you can put them in the Q&A box on Zoom or the comments section on Facebook. We'll review all questions put in the chat boxes during the Q&A session at the end. Please remember that this is a public forum and Legal Aid is not representing you at this time. Jim will go over this in more detail, but please remember to keep your questions as general as possible, as we cannot provide any legal advice specific to your individual situation. The session will end when there are no more questions, and regardless of where we are, we will have a hard stop at 4:30 p.m. With all that being said, I'm going to pass it over to Jim to get us started.
Well, thank you, Marissa. And thank you all for joining us today. I really appreciate your being here. And I hope you find the presentation to be informative, and I look forward to your questions at the end of the session. So again, just to repeat, my name is Jim Morgan. I work in the Wilmington office of Legal Aid, where I am currently serving as the interim managing attorney. And I'm also the co-manager of Legal Aid statewide family law and domestic violence practice group. I've been with Legal Aid for quite some time, and before coming to Legal Aid, I was in private practice. So again, I just want to thank you all for being here and hope you find the presentation to be helpful. We will give you a link where you can go to find the online pro se forms. And if you do that at some point, I would just encourage you, if you end up deciding to file for your own custody complaint, your own custody case, to go through that very meticulously, because what we're doing today is really an overview. You just probably cannot capture everything you need to know in the verbal presentation. But hopefully, we can add to your knowledge. So you see on our first screen, my first screen is the title of our presentation, Child Custody and Visitation. Now I'm going to move over to the next screen. All right. Went a little too far, I'm going to go back. All right, so custody and visitation in North Carolina. So there are a number of statutes meaning the written law in North Carolina that talk about or provide the law for custody and custody related issues. And two of the main statutes are listed in this page: North Carolina General Statute 50A. When you see NCGS, that's just an abbreviation that I've used for the North Carolina General Statutes. Also, another statute that addresses custody is GS 13.1. It's a supplementary part of the custody statute. The first item to talk about is the legal standard for establishing custody in North Carolina. We're only talking about North Carolina law, even though you would find that many of the states' laws in this area are similar. We're going to address only North Carolina law. But basically, you have as a threshold issue, in order to be awarded custody, you have to establish that the parent is fit. And then secondly, if the parent is found by the court to be a fit and proper person to have custody, then the next issue would be, well, what visitation or custody arrangement would be in the best interest of the child. So in all custody cases, a judge is looking at, number one, is this parent a fit and proper person to have custody of the child? And basically that simply means, are you a parent, natural parent, or is there some substitute that might apply? And then secondly, the court wants to ensure that that parent has done nothing that neglects the best interest of the child or any abuse that would basically pull back from that parent's rights to custody, because parents have have a natural right to custody of their children, but they can lose that status based on abuse or neglect. So first, a court is looking for, is this parent fit and proper to have custody? And then secondly, the court, in determining what the visitation or custody order would be, has to determine what is in the best interest of the child. It's not what's in the best interest of the mother or the father or anyone else, but what is in the best interest of the child. That doesn't necessarily mean what the child wants, but it's the judge's duty to determine what would be in the child's best interest. In some cases, you might find that neither parent is available. Maybe they have passed, or both are not able to take care of the child for any number of reasons. Perhaps they've neglected the needs of the child, in which case, and only in a case like that could a court then consider granting custody to some other third party. All right. So let's talk about some terms that you would hear. If you already know these terms, then understand. We just want to make sure that we're not missing any important terms that are not clear to people. So the plaintiff is the person who initiates a lawsuit, which would be a petition for custody. The defendant is the other side of the case, the person who has been served with a complaint and a summons for child custody. So the plaintiff is the parent that initiated the legal action, and the defendant is the person being sued. Now, some people are, get sort of scared about the term being sued. Well, in a sense, it's a lawsuit. It is a lawsuit, but it doesn't necessarily mean a bad thing. It just simply means that a party is making a request for determination by the court of what the custody arrangement should be. Pro se. Pro se simply means that someone is representing themselves, that they don't have an attorney. So you might say someone filed a pro se custody action. In other words, they filed the custody action without an attorney making an appearance in the case. So then we have a number of different forms of custody, and you've heard these before. Primary custody means the person that would primarily take care of the needs of the child. So if you would say that a child lives primarily with one parent, lives with that parent most of the time, that is typically what we mean by primary custody. So court might say, I'm going to grant legal custody to both parents, but I'm going to grant primary custody to the plaintiff, and I'm going to perhaps award custody rights to the other parent, to the defendant. You notice I didn't say that the court would grant primary custody to the mother and visitation to the father, because in North Carolina, there's no presumption in favor of mother or father. It's neutral. So It used to be, many years ago that there was a presumption in favor of the mother. We don't have that anymore. So it's hard for some people to understand at times. Doesn't mean, a negative on either side, but primary custody just simply means that's the parent who has the right of the child or children living with that parent most of the time. And then visitation would be what the other parent has when one parent has primary custody. It's actually fairly rare for a parent not to be awarded at least visitation. So typically you could expect if a judge says, I'm going to grant primary custody to the plaintiff, then the next thing the judge says, I'm going to grant visitation rights to the defendant. Of course, that can change based on the abuse and neglect and those types of issues. Incapacity. Legal custody. Legal custody simply means that the judge is awarding custody or visitation rights to one of the parents, one or both parents. And quite typically, the judge will award legal custody to both. But then, after doing so, would make some decision about visitation or primary physical custody. So legal custody meaning that a parent has a right to school records, right to information about the child's medical appointments, and has some say-so in the major decisions concerning the child would be legal custody. And again, typically both parents receive that. But, people have to live someplace. And so typically, one child is going to live primarily with one instead of the other, and then visit with the other at some interval. For example, every other weekend, half of the holiday time period, something like that, whatever is in the best interest of the child. Then physical custody means, who has a child in their home at a particular point in time. Judge might say, mom has physical custody one part of the week, dad has physical custody on another part of the week. More terms. We've talked about primary custody already. Sometimes we hear of the term sole or exclusive custody. Quite frequently, people who are in a custody dispute will see a lawyer and say, I want to file for sole or exclusive custody. And you can file for sole or exclusive custody. In other words, ask the court for sole or exclusive custody. But as I mentioned earlier, that's actually quite rare, but it's a possibility if a parent has neglected the best interest of the child, the needs of the child in a pretty substantial way. Because basically parents have a constitutional right to raise their children unless they waive it by some bad act or just inability. We talked about joint legal custody a minute ago. Joint physical custody would be living with both parents or each parent part of the time. Visitation would be, it might be overnights on a weekend, every other weekend, or it might be an hour or two in the week. It might be supervised. It might be, an afternoon in the park. It might be in the at McDonald's, or it might be the lobby of the sheriff's department, depending on what the court finds to be in the best interest of the child. And then sometimes we hear the term standard visitation. There may be a little bit of variance in what that means from one county to the other, but basically it's like what you would typically expect to happen when one parent has primary custody. What does the other parent get? Usually they get standard visitation. Standard visitation might be something like that parent can have the child stay at their home every other weekend, maybe Friday evening until Sunday evening. And then shared holidays might be, half of a holiday period, or it might be an every other holiday. Like, for example, one parent has a child Christmas. Next year, the defendant has the child for Christmas. Or it could be, you divide up the holiday time, school holiday time, and the court makes a determination about when, you could switch off during that time period, so that both parents have an opportunity to visit with the child during an extended vacation, like Christmas. Might be, I'm going to order that the child can stay with the mother during the Christmas holiday time until Christmas Eve, 5 o'clock, and then at that point, dad can have the child for the remainder of the holiday, or vice versa, something like that. And of course, as a party to a custody case, you can argue for whatever you think is appropriate. And that's what an attorney would do. Make an argument about why it should be in the child's best interest to for a specific type of custody or visitation. So I just throw these terms out because they mean different things, and it's good to be familiar with them. Big question arises sometimes when there has been no lawsuit for custody. Perhaps the parents were living together, they separated, and the question is, well, do I have a right to keep the child? Or can I move with the child? What if the other side objects? Can the sheriff's department go and get the child and make the other parent, come back? Those are frequently asked questions. In general, if there is no court order in effect, law enforcement will not get involved. Because if they make a determination that both persons involved are the parents of the child, then they would typically say, I'm sorry, but that's a civil matter. You need attorneys to resolve this, and ultimately perhaps a judge to deny it. But I can't, as a law enforcement officer, decide whether or not you can withhold the child from the other. I can't make the other parent bring the child back to you. Slightly different scenario if we're talking about somebody who's not a parent. But if they're both parents, law enforcement, for the most part, going to be hands off until there's some type of custody order. And even when there's a custody order, law enforcement's instructions have to be very clearly made by the court, because they can't and won't typically exercise discretion. They're only going to do what a court order tells them to do. Big question is, hey, I would like to move out of state. I want to go to South Carolina where I have family support and I have a job. Who will be better off there? Plus, maybe the argument is, the defendant has been abusive. I want to get away. I think this would be, can I just go? Can I take off? Well, it's a complicated question. Generally in North Carolina, there's no rule that says a parent cannot relocate with the child if there's no custody order. That may or may not be in the best interest of the child, however. So if you're moving away with the child in a way that's going to deprive the other parent of access to the child, and it's just really for no reason, then that's something that a court might go back and look at and say, I can't find that it was a good idea for you to relocate. The law didn't say you couldn't, but I don't think it was the best thing for the child. And you should have known that, because You knew that, the other side was not abusive. You knew that they were going to lose the ability to have contact with the child. So it's a question that ought to be considered very carefully. In general, you're better able to access resources in the community where you are already living. And in general, that might be where the child has become accustomed to live. Maybe the child has friends here and they go to school here, may have family here. Doesn't mean doesn't always mean you shouldn't move, but these are all factors that ought to be considered. But the basic legal question, is there a rule that says you cannot relocate with the child? And the answer to that is there's really no such rule as long as there's no custody order already in effect. So, that's why I say in the PowerPoint, two different questions. Question one is, what can I do? But the other question is, what is it a good idea for me to do? A case where you might think about where it might be in the child's best interest to move away would be in the case of extreme abuse. All right, so there are a lot of related issues that are not exactly custody issues, but are related to custody. Child support. Well, that's a whole separate type of lawsuit, but typically or often, attorneys, if they file a petition or complaint for custody, will also add a complaint or or an additional part of the complaint that adds a claim for child support so that the court can maybe resolve that at the same time. You can file separately for custody, but you can also file for custody and child support at the same time. The pro se forms that you may be able to access don't really cover child support, but because it just becomes complex. And I would say that if you're asking for child support and custody in the same lawsuit, it's a good idea to consult an attorney. Try to retain an attorney if you can to do that. But also, the parent who has custody can visit what is known as the Child Support Enforcement Office after you get custody, if you get custody, and they can help with getting child support as well. Divorce, that's really after you've been separated for a year. Excuse me. And then separation, sometimes the issue is, are we separated? You're not really separated until you're living in separate households. And then there are other financial issues that may intertwine with all these issues. Not only child support, but maybe spousal support could be an issue. Equitable distribution means dividing up your marital property that was collected during the marriage. In general, when a judge divides up property, they divide it up in an equitable manner, which usually means equal. But only the property that was acquired during the marriage, not property that one or the other party had prior to marriage, and not generally inheritances or gifts from somebody from the outside. That gets a little complicated. We won't try to delve into that much, but I just want to let you know that these are just related issues that are often filed at the same time. If you hire an attorney, typically they want to file for custody, financial support, equitable distribution, all at the same time. And then you see the term counterclaim. So if I file a complaint, the defendant might file an answer admitting or denying what I've said in the complaint, but they also may wish to file some lawsuit against me, and they could do that in the same legal action, but they call it a counterclaim. So for example, perhaps the plaintiff files for custody, and the defendant files an answer and counterclaim. And in the defendant's counterclaim, the defendant also files a petition for custody. So now you've got two custody complaints, one filed by the plaintiff, one filed by the defendant, and then the court is in a position to consider the complaints, both complaints. But I will say that in a custody case, it's a little bit different from some types of lawsuits in that even if there is no counterclaim, in other words, even if the defendant has not also filed for custody, a court still is bound to enter an order that's in the child's best interest. So technically the judge could award custody and visitation rights to the defendant, even if they haven't filed a counterclaim. But it would be, best thing to do in the interest of making sure you do everything that you need to do would be to file a counterclaim. And it looks like we're about halfway through this part of the presentation. Question might be, should I hire an attorney or should I file pro se? The answer to that is usually going to be, can you afford to hire an attorney? I would say all things being equal, if you can retain an attorney, that's the way to go. It saves a lot of, paperwork on your preparation and running around things that an attorney could do for you. Plus, they can also try to make sure that you're doing it correctly. But, in legal aid, we really are strong believers in access to justice, which means, it's good if we can find a way for people to access the justice system, even if you can't retain an attorney. So, this is why these pro se forums the pro se packet that legal aid has were constructed so that, if legal aid cannot represent you in a custody case and you can't retain a private attorney to represent you, then there's still a way to access the justice system by filing your own complaint. And there's nothing wrong with doing that. Just might be easier if you could hire an attorney. One consideration might be, if you're on the fence, would be, well, does the other side have an attorney? The other side has an attorney. You may feel that you're at a disadvantage, and there may be probably is more of a reason for you to retain an attorney if you can. That being said, attorneys cannot testify, and the parent has to testify. And so even if you had to file pro se and represent yourself, if you can show the court through your testimony or through witnesses that it is in the best interest of the child to live with you, then you can prevail on your case. It's not a situation in which just because the other side has an attorney that they are going to, the other side's going to prevail. Maybe a popular misconception, but again, these issues are important, and if you can retain an attorney, if the other side has one, that's the best advice. Another issue to consider if you're thinking about hiring an attorney would be the complexity of the case. Does it sound like it's going to be a very difficult case? Or is there something unusual about this? For example, are you a non-parent? Because as I mentioned earlier, in general, someone who's not a parent doesn't have status to file for custody, but there are some exceptions. And that becomes complex, and that's something where you should consult an attorney. Or maybe it's complex in the sense of, you also have issues of child support, spousal support, equitable distribution, alimony, those issues. That makes it more complicated, and then there's more of even a more compelling need for an attorney. Um, also just complexity in the sense of, is this a very high stress type of case? Are you is it a very bitter situation? Might be helpful to have an attorney to help calm, your temper level. Confidence level, do you feel that you could are you confident speaking in public and speaking in court, showing documents and that type of thing? If so, then you may be able to handle it just fine. But lacking confidence, you might want to think about having an attorney. And as I mentioned, of course, the ultimate issue, can I afford to pay an attorney? We talked about access to the courts a moment ago. So if you're thinking about filing for custody, what are your chances and what is a judge gonna consider? Well, basically anything that's in the best interest of the child would be something that could be considered. But some things that you might think about if you are thinking about filing for custody, or in the back of your mind, you're understanding that these are issues that would need to be talked about because the court will consider it, would be physical, mental, emotional factors. So and alcohol, drugs, criminal activity. So if one parent has a severe substance abuse problem, that could be a negative to that parent. Doesn't mean they won't give visitation, doesn't even necessarily mean they won't win custody, but it's an important factor for the court to consider. Physical, mental, emotional factors doesn't necessarily mean who's the smarter of the parties, but who's capable physically, mentally, and emotionally to take care of the child. Sometimes people are concerned that, well, I have a disability. Does that mean the other side is going to win custody? No, that's not what it means. It's just one factor that the judge would look at and consider. And it might depend on, how significant, that physical or mental disability is. Sometimes a mentally or physically impaired person is vastly more capable and skilled at taking care of the child than the other. It just depends on the situation. Big issue in court is always going to be, what is the party's relationship with the child? Are you close with the child? Do you do things with the child compared to the other parent? Were you the person who had a close relationship with that child for the vast majority of their lives, or has it just been, from time to time? But the court is interested in the relationship with the child. A judge might like to see pictures of activities between a party to a custody case and the child. Again, primary caretaker, that means if there's a parent who for the most part has been the person who takes care of the child most of the time, day in and day out, might be the one who typically gets the child ready for their meals, feeds them, takes them to the doctor, and gets them to school. The child goes to when they're feeling bad or hurting in some sense. A lot of times both parents are caretakers of the child. But in some cases, you might see that one parent is more of the primary caretaker than the other. Sometimes a thing that we don't think about so much as the child's schedule, particularly as they get older. As a child gets a little bit older and maybe into their middle school and high school age, they sometimes acquire like very busy schedules, and what would be in that child's best interest might in part be determined by the child's schedule. Where do they want to be, need to be? Football practice, band practice, or whatever. Driver's license is important. If you don't have a driver's license, how will you transport, the child from one place to the other? Doesn't mean you can't do it, but you would be thinking about, well, how will I get the child from one place to the other? It's a problem if you have to rely entirely on the other parent to get the child around. The living situation means, like, where's the child been living, recently at the time you filed for custody? So if you're filing for custody and the child has been living with the other parent for a significant length of time, say the last couple of years, and things have gone okay, judge might be reluctant to change that situation if it's working out okay. Doesn't mean they can't do it. Just means that they would consider, where has the child been living. Might determine that they need to live more with, the other parent. But they'll look at where the child has been living, their situation. Are we moving the child to another community? Maybe they would have been better off in the community where they were living initially, where their friends are, where the school is, where their other relatives are. And then again, maybe it would be a good idea to move where they have, we would have access to better resources, such as family support. It's a pretty strong point to say that, I'd like this child to grow up around, the child's siblings or cousins and uncles and grandparents, in addition to a parent. You mentioned domestic violence. Well, one of the statutes that I referred to has a special statute that says one of the factors that the judge must consider when there's evidence of it is domestic violence. So, first, if the issue of domestic violence is raised, the judge would make a decision as to whether or not domestic violence has been proved. And if so, how do we account for that? And what do we do about that? Might be the judge changes the custody arrangement or arranges the custody arrangement to make it safe. So you meet in a public place, pick up the child from, the doorstep, but stay from out of the other parent's house. Or maybe it needs to be supervised, or maybe it needs to be, the visitation needs to take place where the parties are not around each other. Or maybe that the court says that domestic violence is so serious that, the perpetrator, of the domestic violence, maybe their visitation should be limited because they're violent. And then basically whatever is relevant. So what I have just presented to you is a non-exclusive list. These are just factors that come to mind and frequently are considered by the court, but basically anything that you could dream of or think of that has happened or is happening that would affect the best interest of the child is relevant or should be relevant in a custody case. This last line in this slide, nothing from nothing leaves nothing, comes from an old song that I think about, because, and what I mean by that is sometimes both parents go into court and they're so mean and so negative about the other parent, and they're both going at it, that they have nothing good to say. And the judge may look at it and say, this is just a terrible situation all around. I haven't heard anything good. Also, if everything you're saying unless it's absolutely true, is negative toward the other parent, courts sometimes wonder, are they giving this other parent a fair shake? And is that going to become evident to the child? So a child in general doesn't like to see the other parent being criticized or accused of things. Sometimes you have to bring up negative things because they're serious, and the judge must consider it. But often judges find it refreshing when a party is able to identify something positive in the other child, because it demonstrates that you can get along with people and you're willing to get along or try to get along with the other parent, which is important. So now we are at slide number 9. We'll move along. We've got some, I'm just referencing some forms that are accessible. You can find all these forms in Legal Aid's custody pro se packet. They're all bundled together, for your convenience. They also can be filed at North Carolina courts, the North Carolina courts site, www.nccourts.gov. If you go to that site, it's the court system administrative office of the courts webpage, all kinds of information that you can access there. But if you go to the top of that page, there is a at the banner, there is a button you can press for forms, and it'll take you to a place where you can type in relevant information to try to find the form that you need, such as summons we have listed here. Summons is a document that goes along with the complaint informing the defendant basically that they're being sued. You can't find the complaint for custody on the North Carolina court site, but you can find the complaint, a blank, fill in the blanks, complaint for custody and visitation in our packet sample. The domestic civil cover sheet is just a 1-page sheet, which basically you fill out to let the court know what type of case you're filing. There are boxes you can check. And there's one for custody. The Service Members Civil Relief Act Declaration. If the defendant is in the military, some special rights kick in. You can't just take it to court while they're deployed, for example. And in some cases, they have a right to appointed counsel. But the court wants to know and expects to know whether or not the defendant is in the military. And so you're asked questions about whether they're in the military, and if they are or not, how do you know that? It's because you've always known the person, or there's also a site you can go to find out whether or not the defendant is in the military. But that's an essential document that must be filed along with these others. Then we see a form called the affidavit as to status of the minor child. All right, so what that document is a document in which you write out where the child has lived and with whom the child has lived for the past 5 years. 2 reasons for that. Judge wants to know, to get an idea of where the child has been living, but also they want to make sure that there's been no other custody case filed in some other state. And if there has, it might be that the case needs to be determined by that other state. So you're asked questions about whether or not there's already a child custody case in progress someplace, or if there ever has been one in the life of that child, and then where the child has resided and with whom. Sometimes it's been with both parents. And then the child's date of birth, what state they were born in. Then an optional form, if you're going to represent yourself, maybe even if you're going to hire an attorney, but you can't afford the court costs that are required when you file for custody or any other type of request. There's a provision in the law in which you can ask the clerk to waive the court cost. And there are some types of situations when it's basically almost automatic. Would be if you're the recipient of some types of benefits, and then needs-based benefits, and then also if you're represented by a legal aid organization, that could be a reason why the court grants your petition to file without having to pay the attorney's fees. I mean the court costs. And even if neither one of those apply, if you can demonstrate in your affidavit that you don't have the means to pay even the court costs, then they can waive that requirement. The bottom of this form, I mentioned copies. So if you go down to the courthouse and you're filing for custody, maybe you've used our online forms, you're going to you want to have more than one copy when you go in, because when you file it, the court will keep the original. You're going to need another copy to give to the sheriff to serve the other side, or to mail to the other side if you serve it by mail. And you're going to need a copy for yourself. Might be good to have an additional copy. You need the original and at least 2 copies, maybe more. Here's what I was talking about a minute ago. Petition to file as an indigent. Just means you can't afford the cost, the filing cost. And the form you would be looking for, it's in our packet. It's also at the court site, is a civil affidavit of indigency, form 106, G106. Again, as I mentioned, food stamps, SSI, represented by legal services, or some reasons why the court can just automatically exempt a person from the court costs. It has to be notarized. Very important, though, to be very truthful, because this information might be discovered, and if you said something that's not correct, to be very harmful to your case. All right, so now we come to the complaint. We've got 2 things up here at the same time. Well, I think you can see the complaint. I mean, the slide for complaint. Yeah. Well, there is a fill in the blank form in our packet. Important thing to remember is, cannot overemphasize the significance of a legal document. A complaint must contain the essential elements of what you're asking for. I mentioned, so it needs an allegation that you're a parent. It needs a statement that it's in the best, that you are a fit and proper person to have custody. It needs a statement that it would be in the child's best interest for you to have custody. All these must be in the complaint. And if that's not in the complaint, at least those 3 statements or allegations, in the court could drop, might be required to dismiss the complaint. But all the essential elements you will find in that pro se packet. Sometimes people write too much in their complaints. You don't need to write the whole story. That's for court. That's for your testimony. Doesn't need to be a novel. Just you only put in the complaint what you must prove. Maybe a line or two about why it's in the best interest of the child to reside with you. But not everything you did, from day one. In most counties in North Carolina, or many counties in North Carolina, we have a mandatory court-appointed mediation process. So from the minute someone files for custody, they might be given a document with information about custody mediation. And in many counties, it's mandatory. In other words, you've got to, it's really not an option unless it's waived for some type of serious reason like domestic violence or serious abuse. So when you file for custody, it may give you a document with an appointment date for you to meet with a mediator. These are court-appointed mediators. Mediation doesn't cost anything when it's mandatory. And they're going to give the same information to the other side. Sometimes the first meeting is an orientation where you just meet with the mediator and they explain the process of mediation to you, and they talk about the importance of trying to work together and trying to resolve, custody issues in a way that's beneficial to the child. And then perhaps after that orientation session, they then schedule another session where both parents are present with the mediator. And in general, this is something for the parties, and the attorneys are not involved in that directly and not present, to argue the case. They want to free the parties up to try to come to an agreement that is going to be beneficial to the child and is acceptable to both parents. So the mediators are very good at helping parents find a solution to the custody dispute. They talk about your schedules. They look at what's realistic, and then help guide you possibly to coming to an agreement that both parties can live with and that is acceptable. And if they can help you do that, then the mediator will type up a document called a parenting agreement, let you look it over, probably let you carry it away with you, think about it, maybe talk with an attorney, and then let the mediator know whether you agree to it. And then if you both are in agreement with the parenting plan and sign it, then the mediator will have the judge sign it, and that becomes the court order, and you never have to have a trial or hearing in court. So a lot of times people who are in custody cases are very skeptical that anything will be resolved in mediation. But we find that sometimes we're surprised that because some mediators are very skilled at finding a way for you to reach an agreement. And if so, that's great. It becomes a court order. But obviously, not in every case are you going to be able to come to an agreement. So if you just simply can't come to terms on what's in the best interest of the child, and the mediator cannot lead you to an agreement, then the mediator sends a note to the judge, says, we tried mediation, it was not successful, and you will need to hear the case. So then there'll be a trial date set to be heard in front of a judge. That's a custody hearing. It is a trial. So because not everybody is skilled in presenting trials, sometimes mediation is is something to very seriously consider. But again, you're not required to come to an agreement. Nobody's going to penalize you for not coming to an agreement. And if you don't come to the agreement, then it's going to be sent over to a judge at some later point. Another reason why it might be good to give mediation a shot is that sometimes it takes months before you get a hearing in court. And you might want to go ahead and try to find a way to resolve it beforehand. Okay, so now you've filed for custody, the other side has been served. You tried mediation, you couldn't come to an agreement, it's going to go to a judge, and your hearing is approaching. What do you do to get ready for that hearing? What does it look like? Well, first, if you're the plaintiff, the one who initiates the lawsuit, you go first. And you are presenting your evidence. It's going to be your testimony, and it may include testimony of witnesses that you bring to court. You can also subpoena witnesses, and maybe documents, if they're admissible, maybe photographs, it may be video footage. It could be anything that you might be able to show the judge that is relevant, and you can establish as being a legitimate, something that's legitimate. Those rules about, can be complicated as to what's admissible into evidence. But the important thing is you're going to have an opportunity to present your testimony and your evidence concerning what's in the best interest of the child. Technically, the burden of proof on that is on the person requesting custody, so on the plaintiff. But if the defendant has filed a counterclaim for custody, then the burden of proof is on the defendant for his custody petition. Burden of proof means, how convincing does it have to be? And in a civil case, it's by a preponderance of the evidence. In other words, that your case is a bit stronger. The court weighs your evidence as being a little more persuasive than the other side. But what you are trying to establish and get the judge to agree with you on is that you are a fit and proper person to have custody. And it's in the best interest of the child for you to have custody or joint custody, whatever it is you're requesting. Or maybe you're requesting joint custody or just visitation. But that's what the judge is looking for, and that's what you want to present your evidence on. At the beginning of the presentation, we talked about some of the factors. Again, we're going to go back to those a bit because this is what the judge is considering. What is your relationship with the child? Have you been the primary caretaker or joint caretaker of the child? They may need information about the relative physical and emotional capacity of each parent, your work schedules. If you're a truck driver and you are away, most evenings and most days, and it's going to be difficult for you to be a primary caretaker. Not picking on truckers, but I'm just using that as an example. It doesn't mean you couldn't be awarded custody, but you would have to present how would you handle this? Do you have your own family support to help you with taking care of the child while you're on the road? Family support, again, you have a strong family unit that can step in, wants to step in, who's close with the child, will babysit for you when you're sick, or can, help you with different things that concerning the child, or just if the child enjoys spending time with relatives. Substance abuse can be very important. It doesn't mean that because a person has had a substance abuse issue in the past or a mental health issue does not necessarily mean they are going to not win the case. It's just a factor that the judge, it may be a big factor, it may be a small factor. For example, it's not a problem that a parent has suffered for depression. If they've seen a doctor, they're on medication and are perfectly capable of taking care of the child. So you don't have to fear it being disclosed to the court if you've had depression. But, you know, they need to look at things like, or have you gone without medicine so long that you're not able to get up and take care of the child? Maybe with medication, that's all fine, and therapy. Same with substance abuse. Maybe in your past life, you've had a substance abuse problem, but you're on it. You're receiving help for it. You know, then it's being addressed. Court might look at it. Maybe they put some safety mechanisms in there, but it doesn't mean all is lost necessarily. Again, we talked about domestic violence can be a very serious issue. And as I mentioned before, when I mentioned nothing from nothing leaves nothing, you know, which parent is willing and able to work with the other parent? Maybe you can't work with the other parent because they're extremely abusive, in which case you can explain that. And then finally, you know, a judge is going to make a decision. Sometimes they make that decision right after you finish your evidence, after thinking about it for a little while. Maybe they give it a couple of days. But in the court order, the written document that establishes what your custody and visitation rights are, in that document, the judge is going to find whether or not the parents are fit and proper to have the child, and they're going to have a statement about what they believe is in the best interest of the child, and then based on what they find to be in the best interest, establish some type of, usually a schedule, a visitation schedule. And again, just as an example, it might be, you know, I find it's in the best interest of the minor children that they reside with the plaintiff primarily, but also find that it's in the children's best interest for the defendant to be awarded visitation rights every other weekend, every other holiday, something like that. It could be a very specific schedule, or if the court thinks that, you know, you're able to work it out informally, then they might just, you know, not get too specific. Sometimes you'll see some special provisions. For example, they say there's been domestic violence. Well, the judge might put in the custody order that safety mechanisms to make it safe to transfer, you know, the child for visitation. It might say, you know, the parents will meet outside the sheriff's department, or will meet in a public place to exchange the child. Or it might say that, you know, that the mother will let the child open the door, let the child out, and go get in the father's car, but there'll be no interaction between the parents during the exchange. That's just an example. Whatever the court finds would be appropriate to make it safe and be in the best interest of the child. Another special provision might be something like, you know, the court says I'm going to order, you know, one party to undergo a psychological or to attend mental health or substance abuse counseling weekly. Or it might be that both are required to attend a parenting class. That's an example of a special provision. The court has a lot of authority to do things like that. And then you see standard provisions. A standard provision in a custody order would be ones that you typically see that might say something like, you know, I'm ordering that both parents refrain from demeaning the other parent in the presence of the child. And I'm ordering the parents to refrain from you know, asking the other parent questions about their romantic life, something like that. Again, court has a lot of discretion there, and they can do all kinds of things. And that takes us to some links. You're going to be looking for the pro se. I have an extra pros say there. Should left the S on PROS out. But pro se packet accessible at a legal aid site. Just go to legalaidnc.org. And if you look at the top of the screen, you'll see something that says get help. Click that box on, you get all types of options. And one option is information on child custody and visitation. Take you directly to the pro se custody packet. It's a do-it-yourself packet of forms that you can fill out, print, and take to the court to file your own custody case. Comes with complete instructions. They're not too difficult to understand. If you got stumped, if you were confused about any part of that, you could ask someone, probably an attorney. And then also at that help site, there's a demonstration of a custody hearing. And other tools that you can access. I'd encourage you to go there, look around and find things that would help you. So now we come to the end, I believe, of the slideshow. And so here we are.
Awesome. Thank you, Jim. So what we're going to do now is we are going to open it up for questions. Please remember to keep your questions as general as possible, as well as I did post a link to Legal Aid of North Carolina's child custody packet, as well as a link to the form section of the NC Courts page that Jim mentioned. And so just to jump into questions here, the first one, let me scroll back up. If one parent moves to another state with the children, can the parent, I guess that stayed in North Carolina, file for custody in North Carolina, and would that other parent have to come back because the parent who stayed in North Carolina filed in North Carolina?
Well, that's such a good question. So the thing that you need to look at is where the child has resided for the past 6 months, because the courts look at in deciding where a custody case should be filed. They're required to look at where the child has been living for the past 6 months. And whatever state that is considered the child's home state. So, if at the time that you are looking at possibly filing for custody, the home state is in North Carolina, then even though maybe the parent could relocate with the child because there's not yet a custody order, the only place that probably where you would be able to file for custody would be in the state of North Carolina, because that's the home state of the child.
Irritating for us.
Now, however, let's say if the parties separate, there's no custody order, and one parent relocates with the child, I'm going to say, for example, South Carolina, and then 6 months go by and nobody has filed for custody, if the child has then lived in South Carolina for 6 months, then the home state becomes South Carolina. So if a parent relocates with a child away from our home state, then it would be advisable to go ahead and file for custody in the state of North Carolina, so that custody could be determined in North Carolina. Because if you delay doing anything for over 6 months, you might have to go to South Carolina, which might not be convenient, for you. There are some limited exceptions to that, based on perhaps abuse. But even in those cases, ultimately, even if a judge in another state granted temporary custody, when the home state is North Carolina, it's probably going to be limited to some period of time that would enable the parties to return to North Carolina to get custody moving in North Carolina. So biggest thing to remember is the home state is where the child has been residing consistently for the past 6 months. And if that changes and nobody has filed for custody, and then that home state can change. I hope that answers the question.
I think it did. Next question. Someone's asking if one parent has moved away to a different state, has never made any attempts to visit child, rarely called, and the child has stayed with the parent that remains in North Carolina, has been with that parent their entire lives. That person is asking if they're looking at filing for custody, do you think it would be a good idea for them to still hire an attorney, or do you think in that kind of a situation they could file themselves?
Well, I mean, I think that I don't know necessarily I don't see a pro and con on that issue about whether somebody should retain an attorney, because either side could file for the pro se forums. But I mean, it does sound like, based on that scenario, that the parent who has not had much contact is going to have would have a difficult time in winning custody. And then visitation they might have to ease into custody. Ease into visitation to a point where and could possibly be expanded over time as a child gets to know that parent who's been away for that period of time.
Perfect. Um, Making some assumptions here. A situation where a child is living with great grandparents because neither of the parents had the ability, I guess, to have the child in, and
Mm-hmm.
one of the parents is now threatening to take the child elsewhere. So the child has been living with these great grandparents for quite some time. Child's father is okay with that. Everyone else is fine with that situation, but now it looks like a child's mother wants to change that situation in objection to everyone else involved.
Yeah.
Not really sure what the question is there. I'm assuming they're
Well,
asking would
I
filing for
think maybe
custody be an idea?
I think maybe I can hit on some issues, and maybe it will kind of answer it in part. But that's getting into an area of custody law that we as lawyers sometimes refer to as third party rights. And as I mentioned, in general, it is only the parents who have custody rights to the child. However, if the parents are in a custody case, have filed for custody, the law does say that grandparents can intervene in that ongoing custody case to request custody or visitation rights. So that's one way grandparents can be involved. And then, but if not, let's say that neither parent has filed for custody. So that's the only way for the grandparents to intervene. Unless, second way for grandparents to get involved would be if they can establish in court that both parents have neglected the best interest of the child and basically waived their natural constitutional rights by either neglecting the best interest of the child, or abusing them, or abandoning them, or giving them up. That's kind of a difficult scenario. That's where a person, the grandparent really should seek legal custody. Number one, because we don't have pro se forms that fit that very well, that situation. And secondly, it's complex, and if it's not done correctly, it could be thrown out of court. And so, but again, there's a lot of deference given to the rights of parents. But if it's, if both parents have neglected the best interests of the child, and there's no parent that can reasonably take care of the children, then that might be a situation where a grandparent could file for custody. They just have to show that both parents have neglected the best interests of the child, or abandoned them, or handed them over to the grandparents.
Perfect. Couple more quick questions. How long does it take someone to get full custody of a child? And does it matter whether or not that child is school aged?
How long does it take? Was that
Yeah.
okay? It really depends. it might be, it can depend on how crowded the county is with custody cases and other cases. If it might be that, you go through mediation, you get a court date within a few weeks, and the whole issue of permanent custody or exclusive custody is determined like, within a month or two. But when you use the term permanent custody, that's a little bit of a misnomer, because after a custody order has been entered, either party can ask for a change in the custody order based on a substantial change in circumstances that have occurred since the last order. Example would be, say, defendant has a severe substance abuse problem, but then maybe 6 months later, that parent has addressed those problems and it's no longer a risk. Maybe that parent then petitions and says, I would like my visit to request visitation at this point, and the court can revisit it. So in a sense, there's no such thing as a permanent custody order, except if the situation is so horrendous that the judge terminates the parental rights of a party. That's an extreme case. And as far as the child's age goes, there's no clear rule on that. But generally, when a child is an infant, it's kind of assumed that they don't know how to express themselves in a way that would be helpful to the court. But as they grow older and understand themselves and the world and their parents a little bit better, it becomes if they wanted to talk with a judge, maybe in chambers or testify, as they get a little older, a judge may give weight to what the child's preferences are, but they're not bound by the child's preferences. Common scenario is one parent believes that the other parent has is not maybe a very good parent, except for they reward the children with a lot of fun things. And so maybe temporarily a child thinks they want to live with one parent when it's not in that child's best interest to live with that parent. But as a child grows, they become more capable of helping the judge make that determination. And when you get maybe 13 or 14, at that point, a child as a human being kind of knows what's best for them and can express that to a court. But there's no point at which a judge is bound by their preferences that they've expressed.
Would a parent not working impact their ability to get custody?
Not necessarily. And generally, I would counsel clients not to worry about that very much, because typically, there are different roles that parents have played, in the relationship with each other and with the child. So it might be, you can look at it as a positive that the defendant has, earns a really good income, shows that person is capable of providing for the child materially. But it may be that the parent who's not working outside the home has been taking care of the child and is very and the child is used to being around, and their responsibility has been basically to take care of the child. So it's a factor that the judge would look at. So at the same time, they don't want to necessarily penalize a parent for working. So they would find a way, to do what would be, but helpful to the child. But it's not so simplistic ever to say, well, one's got a better job or works, and therefore we're going to favor that parent.
Okay. We have a couple questions asking about what happens when uh, child custody order is not being followed by either parent.
Okay. All right. Okay. So two things you think about. One would be, if they're serious enough to be of concern, then it's possible that the parent who's non-compliant could be held in contempt of court because a custody order is an order of the court. It's the judge saying that the parties have to do certain things. So to willfully violate the court order can be contempt of court, and the judge could actually punish that non-complying parent. And the form of punishment might be, that they're jailed until they comply, or it could be usually not that severe, or it could be that they they have to do something, pay a fine, or they have to adjust their conduct in some way, or or the judge says, makes it more clear what that they need to do, and it says we're going to return to court in a month and review this. So in other words, one way of enforcing, making sure a parent complies with the order is contempt. So the parent who is complying with the order might consider filing what is called a show cause order, which is basically a request to hold the other side in contempt of court. They can schedule a hearing, and the judge can take a look at that. But the other thing to look at would be, it might be that if that parent is not complying with the order, then that could possibly be sufficient for a change in circumstances that would persuade the judge to change the custody order, to maybe reduce that parent's time with the child, to give the parent who is complying with the order more time. So not complying can be a big problem to the non-complying parent, because it could result in, number one, being held in contempt of court. In other words, getting in trouble. And secondly, they might end up with a less favorable new custody order.
For those of you asking about child support, remember this presentation is about child custody and not child support. Next question. What happens when a child wants to spend time? I'm assuming there's a custody order in place, but the child wants to spend time with one parent who's not supposed to have who's not supposed to have the child at that time. I think that. Let me know if I need to repeat that because I don't know if it makes sense.
Yeah, maybe it would help to repeat it if your child wants.
Let's just say a child is supposed to be with their mother, but they want to go with their father, but it's the mother's day to have the
Oh,
child.
okay. Yeah, I got you. Well, okay, so that's something that comes up in court a lot. And sometimes from the judge's perspective, they're thinking, yeah, children are going to say that, but you're a parent and you're responsible. You need to encourage them to go with the other parent, unless there's some reason why they shouldn't. And if there's some reason why they shouldn't go to the other parent during their time, then we'd probably need to address it. Now, there may be circumstances there where it's just like something special is happening. And then if both parents are okay with that, then the judge is typically going to be okay with the child spending some extra time with one parent, even though it's not strictly in the court order, as long as both parents are okay with it. But I think what they really get impatient with is, when one side says, well, the court order says he has to go visit with his daddy, and when I started to take him over, my child started crying. I can't do it. I can't take him over there because he's crying. judge usually would say, man, you need to talk to your child and teach them to listen to you, and communicate with you if there's a real problem. But the defendant is their dad, and they need to go. He has a right. So it's not an easy way of just changing an order that you don't like.
Perfect. Quick question here. Some are asking about third-party visitation. Is that child custody packet, is that the same packet someone would use to file for third-party
If I'm not
visitation?
mistaken, I don't think our packet really addresses the third party custody visitation. And so I would say if that's becoming an issue, it's probably complex enough. It would be advisable to seek counsel.
Perfect. Okay. That answers a couple of those. Someone's asking, after they file for custody, how long do they have to wait to serve the other party?
I mean, you try to serve them immediately at the time basically you get a copy of what you filed, and it should go immediately to the other side for service. Either it's served by the sheriff, or the alternative is to serve them by certified mail. But that's supposed to happen, almost simultaneously with like the same day that it's filed. But whether or not they can be served quickly is a different issue. You need to know where they are, and sometimes the sheriff has trouble finding them. Maybe they avoid being served.
Perfect. Let's see. What happens for a situation where the children reside with one parent, haven't seen that other parent in a while? Let's say the children reside with mom, haven't seen dad in like over a year, and then dad files for visitation. Does it seem likely that a court would give dad visitation even though he hasn't seen those children in, quite some time?
I mean, it's going to be a factor that the judge needs to consider, because and typically you want to make a child comfortable about what's happening. So you wouldn't typically, throw the child into a lot of visitation or custody time where they've not been. So a judge might look at a way of building on that, like start with short visits, and in the custody order it could say, we'll begin with visitation for 2 hours every month, and then after 3 months we'll move into once a week, and as long as things go well, then we'll increase it even more.
Let's scroll. What types of evidence can be used at a custody hearing? Can something like a text message be evidence used at a hearing?
Yeah. So I mean, that's a good example. Now, but there are rules about what type of evidence could be introduced and the way you introduce them. So you need to be able to show the judge or testify to the judge about, how can you identify that text message that you want to show the judge actually came from the other side. Like, for example, if it's coming from a telephone number that you can't identify, how do you know it came from the other side? Well, maybe the answer is, well, we're discussing issues that nobody else would be discussing, because it pertains to our relationship or the relationship with the child. Or maybe, the answer is, well, this text message doesn't show the defendant's name anywhere, but that's a telephone number that he has used in the past, and we've communicated with, and so that's how I know it's the defendant. But you have to satisfy the judge that this is actually what you're claiming it is. Like a photograph, you've got to show generally the date to testify to what date it is. and that it fairly and accurately shows what it is you're trying to show, and you haven't like changed it, edited it in any way. So it would be like, here's a photograph I took on June 1st, 2025. It shows, the child with me, at a museum and, smiling. And this is an example of, and, I haven't modified or, haven't, tricked out the photograph or anything. But there, for every type of evidence, there's some type of rule about how to produce it. Again, that's when if it gets complicated, that's when you might want an attorney. Good thing is anybody can present verbal testimony, about all these issues we've talked about.
Okay. This one might be too much to answer in this form, but I'm gonna try to make it general.
Okay.
Where'd it go? Okay, so one parent filed, let's say mom filed in one county for custody, then in okay, so I just think that's too specific. That's just too much. Okay, let's move on. Um,
Yeah, we
so-
don't want to try to address anything that sounds like we're giving advice up to a specific person, because
okay,
rules of confidentiality and a lot of things like that. Plus, other people may be watching.
okay. Say that there was a custody order in another state, and one of the parents has now moved to North Carolina and might be looking to modify that custody order, but the children still live in that other state. Would that person be looking to modify that out-of-state custody order in North Carolina?
Might have to go back to the out-of-state court and make a motion to allow it to be transferred so that you could file something in this state, because it's now, you believe it's in the best interest for the any further hearings to take place in this state. But it's a problem if the children are still in that other state, because that's not, they typically want, the desired forum or place for custody is going to be where the children, have the connection.
Perfect. Um, Situation where one parent has filed for custody and is now preventing a grandparent from having visitation with that child. Would this be a situation where that grandparent could file for visitation to be able to see that grandchild?
Well, you got two things there. First, grandparents typically don't have rights, but unless they intervene, file
Oh,
a motion to intervene in an ongoing custody case between the natural parents, or if there are no natural parents that can handle the responsibility. But so there may not be a way for the grandparent to approach it. However, between the parents, if it looks like for no good reason one parent is not allowing the child to visit with grandparents who could be helpful to the child, and has a good relationship with the child, it would seem like a negative factor, and that could possibly be a motion to modify the custody order to change it. But it would be something that the other parent has to do, not the grandparents. But maybe that parent says, well, this is not good. The other side will not let our child visit with my parents, and they've had a very good relationship with them. And I think that the court should, modify the order to permit that. It's just the problem is, who can ask for it? And so that's the issue. Again, that gets a little complicated. That's a little hairy there, but and complicated. Anytime you get into third party rights, grandparents.
okay. Kind of along those same lines. This is a situation where child has been staying with great grandparents. The father of the child is on board and wants to keep that agreement, but the mother wants to change that agreement. Should it be the father who files for custody, or should it be those great grandparents who would file for custody? So no parent is seems like no parent is unfit or anything like that. Just trying to figure out who might be the best party to file. Would it be the great grandparents or the father? And
I might
not
need
sure
that
if you can ask
repeated.
that
I'm
question.
sorry to have to ask it, but it's
No, no. Situation is where there's an agreement between the father and mother where the child is to stay with the grandparents.
okay.
Mother now wants to change that agreement. Father does not want to change the agreement. Who should file for custody? Should it be the father or the great grandparents? I think that's the question.
So I don't think the great grandparent can file. You know,
Mhm.
as long as there is a parent who is capable of either one or even one parent who's capable of. So it would be one of the parents that need to file. And if they do file, then the grandparents can file a motion to for the court to consider visitation rights with the grandparents, great grandparents, whatever. Um, but it could be either parent, but it would be whoever wants some type of protection or in the who wants something is going to be the the parent who files for the custody, who's not happy with the situation. You said in the question there's an agreement. Well, an agreement is one thing. If it's a custody order, then that changes everything.
Hmm. Um, if someone filed for custody here in North Carolina, but the other parent lives out of state, how does service work then?
Well, it just becomes more complicated. It works the same way, but the complaint will need to be sent to the sheriff's department in the city where or county where that other parent, that out of state parent resides to serve them. Or you could serve it by certified mail, and if they sign for it, you could in it's just the same way. There's no difference except it might be more difficult because they're so far away, and you've got to talk to some agencies who are not like right near you, and to get it there.
Last question that I think we can answer in this type of a forum. Someone's asking about parental alienation. Not sure if that's something we have in North Carolina,
Well,
as
okay,
well as,
so that's a
go ahead.
term that is kind of thrown around a little bit, and it's really controversial. The idea is that one parent is doing things that poisoning the child's minds to turn against the other parent. And some people argue that it takes very little to do that. Um, and then others argue that it's very difficult to really do that. So it's a and it's one side argues that it's not really a legitimate because scientific evidence doesn't really back it up. Others may say it's a very practical thing that it happens. So it's that's a difficult issue. Safe thing is to always remember, don't try to do anything that will poison the minds of the child against the other. And if it's turned on you, you might need to consider hiring an expert to talk with the child so that you can prove it's not happening.
Okay. Again, we cannot respond to specific questions. So if you're noticing your question is not getting asked, it's because we cannot respond to that. Interesting question here. Not sure if you can answer it. What happens if there's a custody order in place, but the two parents decide to start living together again?
Huh.
But
Oh,
the custody order stated that only one parent had full custody.
wow.
When those parents start living together again, do both
Okay.
parents now have full custody? Or does it just,
It's
or is
not
the order
automatic.
still in
It's
place?
really not automatic, but that would be a good basis for someone at some point to file a motion to change the custody order based on changed circumstances. A judge might say, well, neither side have practically been following the order. So, I'm going to open it up to a whole new determination. I'm not going to hold, either parents to what, the previous order was, because neither one is really complying. But it doesn't have an automatic effect of erasing or erasing the order. It doesn't become void just because that happened. A judge would have to say, I'm going to consider it defunct. I'm going to change it, but it doesn't just happen automatically.
Okay. Okay, last two questions, hopefully. Okay, here we go. Um, in a situation where there is an absent parent, what are some things or some tips that you might have for the present parent to take into that custody hearing to present, kind of showing the absenteeism of that other parent? I'm assuming is what the question is asking.
Yeah, well, I would you want to document as best you can, how that has happened and when it has happened. I mean, if you have like a log of particularly if it's something in important dates, for example, the child's birthday or holidays, if you're able to testify and you have a list or maybe a calendar, here's another birthday where my child didn't hear from his daddy. It would be example. But it's not very persuasive to say, he never hears from the other side. It would be better, to document, how long it's been, what important dates were missed and why, and what efforts maybe that you made to try to engage the other parent. It was our child's birthday was coming up, so I called, the father to ask him if he wanted to spend some time, and I never heard back from him. Those types of specific examples can be helpful.
Perfect. And then last question, would a judge ever question why one parent decided not to give the other parent additional time beyond what the court order says?
Well, I would say in general, not so much, because you're complying with the order, then you should be okay with the judge. But let's say, based on the circumstance, let's say something is really important. Let's say, the dad has primary custody and the mother had some special event. She had a graduation. She's getting her high school diploma for the very first time. And it's not in the court order that the child can see the mom on that particular day. And then just out of meanness, the parent who has the child says, no, you can't go. When there's no reason that it would be good for the child and good for the other parent. So that might be an example where the judge says, that's not really doing what's best for a child, even though strictly speaking, you weren't required to do that by the terms of the order that I entered 6 months ago.
Perfect. Awesome. Well, I am not seeing any more questions, so I'm going to go ahead and say thank you to Jim for presenting for us. Of course, thank you to all of you for joining us and to Jim for answering all those questions. If you would like to review anything that was discussed today, we have posted a recording of today's event to our Facebook page. It will be immediately available. You can access this recording with or without a Facebook account at www.facebook.com, excuse me, /legalaidnc. Um, in about a week, you can also access this recording at any time on Legal Aid of North Carolina's YouTube page. If you would like to register for one of our other Listen and Learn events, such as Simple Divorce, Tenant Rights, Medicaid, you can do so on our website at www.legalaidnc.org/clinics. Thank you all so much, and I hope everyone has a great rest of their afternoon.
Thank you.